Good day, Crime Talk aficionados. Thank you for tuning in to Crime Talk. My name is Scott Reisch. First on the docket, Patrick Frazee. This guy just may walk. Second, these two cops are walking. No charges for police officers who shot a man while he was running away. And third, our daily contestant for the Dumb Criminal of the Week. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and I am a criminal defense attorney with 25 years of experience bringing to you explanations of criminal matters throughout the state of Colorado and the United States. First on the docket, the Patrick Frazee case being tried here in Teller County, Colorado. That is just south of Denver, down by Colorado Springs, and you take a hard right as you're heading south. Patrick Frazee is accused of first-degree murder for the death of his fiancée, Kelsey Barrett. Despite investigators never recovering her body since she was last seen on surveillance video inside the Woodland Park Safeway on Thanksgiving of 2018. The Woodland Park police have not found Barrett's remains. Barrett, who is 29, is presumed dead after prosecutors said Frazee, who's 33, beat her to death on Thanksgiving of 2018. In December of last year, Patrick Frazee was arrested and charged with first-degree murder and solicitation to commit murder in the first degree. The on-again, off-again wants to be the permanent boyfriend of Patrick Frazee, a nurse from Idaho, Crystal Lee Kenny, was charged and pled guilty to a Class 6 felony here in the state of Colorado of tampering with an evidence. She is technically eligible for probation. She could get a halfway house, and the presumptive range, if she were sentenced to the Colorado Department of Corrections, would be 12 to 18 months, and that could be as high as 3 years if she was technically aggravated. Aggravated would mean that she was on probation, on bond, parole, or escape status, none of which applied, but Miss Kenny has agreed to allow the sentencing to go up to the 3-year mark in exchange for this plea. And if Miss Kenny was ever sentenced to the Colorado Department of Corrections, she would also have to serve a 1-year mandatory period of parole. Now, the prosecutors have a tough case. In this particular case, why is it so tough? 1, there's no body. 2, Crystal Lee Kenny, the prosecutor's key witness, has some motive to get rid of Kelsey Barrett. She testified that she was asked and that she agreed to commit the crime of murder against Kelsey Barrett on 3 occasions, but that she chickened out. How many times does it possibly take to commit a murder? Well, I'm sure the defense is going to argue in closing argument the 4th time, because Miss Kenny's story has problems with it, okay? There's video available at the house. It shows Patrick Frazee going in at various times where he said he was there. It doesn't have him going in at certain times when the police and the prosecutors thinks that he should be at Kelsey Barrett's apartment or condo. And who, according to Miss Kenny's statement, gets a call and basically heads out Thanksgiving Day to Colorado to clean up a mess because your wannabe boyfriend says you have a mess to clean up. And then she says she did it because she was scared for her safety and that of her family. Of course, there were apparently no threats ever made that anybody else can know about, just Miss Kenny. Isn't that convenient? She drives all the way here, cleans up the place. While driving the 12 hours from Idaho to Colorado, never bothers to call the police, doesn't bother to pull over to any city, town, municipality and pull over and talk to the police and say, I think there's something bad that happened. Please help me, okay? There's a defense called duress, and that's basically someone made me do something, but as soon as that duress is gone, you have to immediately go to the police to have that qualify. 12 hours driving, she had plenty of time to think about it and do what she was doing. Coincidentally, there's also no DNA evidence at the residence of Crystal Lee Kenny. Now, maybe that's because she was put on a biological suit to clean the place up, and she cleaned so well. But then she says, I left a couple of items there at the house of blood and this tooth, apparently, so that I could, help everyone catch me and Patrick Frazee in the case. Kind of a hard story to really buy. So what does the prosecution have to do? They're trying to corroborate everything that she has said so that it looks like she is believable. What did they do? Okay, they said she went and got gas. They got video from a gas station. Okay, fine. She says that she destroyed the phone, that she took burner phones and out of Barris that she threw away. She told them where it was, but they never found it. She said, well, we went to the ranch of Frazee and we burned everything. And so on a farm in a barn, they find some cans of oil. Okay, that aren't burned. Okay, cans of oil there. They find a gas can in a barn on a ranch. Not surprising that you would find something like that there. Then they said there was a burn area. And this is where apparently this tote was burned by Patrick Frazee, and he used all these oil to make it hotter. The Colorado Bureau of Investigation, FBI, have gone through this. They found nothing. The tote obviously is not there. The metal hinges that were supposedly on this tote are not there. And they find what they believe to be this partial remain of a tooth at the farm. And we'll talk about that in just a second, but it didn't exactly turn out the way they thought it was going to. So that's where we kind of pick up today with the evidence that was presented yesterday at trial. The witnesses called yesterday were scientists from the Colorado Bureau of Investigation, and they were there to do is testify that we went to the crime scene, we took what we believed to be blood, we did a presumptive test, and it, in fact, turned out to be blood. And then they explained how they tested for DNA and the results. And they went through various items of evidentiary value, i.e. blood, that they believe they found at Kelsey Barriff's apartment. And first, they found blood, and a lot of it, the blood there, was a mixture, which means there's two people's DNA in this mixture of blood. One was that of Kelsey Barriff and an unknown individual. The police have the DNA samples so they can compare the DNA of Crystal Lee Kenny. They also have the DNA of Patrick Frazee that they obtained via a 41-1 search warrant. And they also had to get the DNA of the previous owner of Kelsey Barriff's apartment, a Sue Gorney, because her DNA was found there. Sue Gorney's DNA was found on the floor that was cut out at Kelsey Barriff's apartment, where they found some of Kelsey Barriff's DNA. And Miss Gorney admitted that she bled when she was moving out. She bruises easily. She has kind of thin skin, and she bleeds. So it's not particularly surprising that her DNA is there. Even if Patrick Frazee's DNA was at the residence, be like, so what? I was there all the time. DNA, it can come from your hair. Skin molecules, it's cells. So if they find it, you have dry skin, you flake, you've just left your DNA there. If they were to swab a table or a podium, let's say I go to court and I touch the podium, they come and they swab it and they get that DNA, they can say, hey, Scott Reisch's DNA was there along with 50 other people, but they can't say when it got there, how it got there, under what circumstances at all. It just simply says that the DNA was there. The blood on the baby gate was that of Kelsey Barriff. The defense simply argue she must have cut herself with sharp edges on the baby gate. Pretty straightforward and not a whole lot there. The scientists also went on to testify that the burn area where they thought that they had found blood, in fact, turned out not to be anything. This blood-like substance, and this is why they have to refer to it as a blood-like substance until somebody who actually tests it can say it's actually blood. Here they thought it was blood. Turns out it wasn't. They did a presumptive test, not blood. They said, fine, we'll take a look at it and we'll see if there's DNA. And it comes back nothing. So what they were looking for turned out not to be there. There was supposedly a tooth fragment found out at the property. Not only did they test the DNA and said, it's not human DNA. I talked about it a couple episodes ago where they have to prove that it's actually a human's tooth. They have to prove that it's Miss Barrett's tooth. And here, it could have just been an animal who lost a tooth. And in fact, that's what it turned out to be. They checked this tooth for blood, negative. No saliva found on it, and not enough material to actually obtain more DNA. The blood on the fireplace was a partial DNA sample, and so they couldn't even actually say if it was, in fact, Kelsey Barrett's blood. But I assure you, if it had been Patrick Frazee or Crystal Lee Kenny's blood, they would have let everybody know. The prosecution also brought in a forensic anthropologist by the name of Dr. Diane France. She testified regarding her work with the search of the landfill where the Fountain Police Department for over a month was going through a landfill looking for something to do with this particular case, and they found nothing. As a forensic anthropologist, she can also opine as to what she thinks old bones may be, things of that nature. And she stated on cross-examination that she was not even sure that it was a human remain of that particular tooth. The prosecution also brought in several people that worked with Kelsey Barrett at her flight instructing job. And, of course, they brought in people to say, oh, she was nice, she was sweet, we don't think she had an alcohol, we don't think she had a drinking problem. We weren't really aware of any depression issues, which has come up in this trial. But one witness did, in fact, testify that she was kind of going through some mental fatigue, but they kind of attributed it to having a busy schedule, being a single mom, and just being run ragged. No one indicated anything about any threats or anything of that nature that Ms. Barrett had expressed to them from Patrick Frazee at all. This, ladies and gentlemen, is what we call filler. Those are witnesses to fill time, to fill space. What element does that go to prove or disprove of the charge of murder in the first degree? She's a nice person? Not an element. You know, the district attorney is looking for sympathy because, and not just as a defense attorney, as a lawyer, someone looking at this try to be as intellectually as possible, is that the prosecution, I don't think, has made their case of proof beyond a reasonable doubt to each and every element of the offense charged. They just have not done that in this particular case, in my opinion. If the jurors think he probably did it, I think he did it, I really think he probably had something to do with it, guess what? That's not enough. That is reasonable doubt. It has to be, I am absolutely convinced, beyond a reasonable doubt, not a shadow of a doubt, but proof beyond a reasonable doubt, which is defined as not a vague, imaginary, or speculative doubt, but a doubt that would cause people to pause in matters of great importance. So we have Kelsey Barrett, who no one has seen since last Thanksgiving in 2018. We know that she had kind of some mental health issues, maybe just exhausted, maybe a little depressed. Who knows? But we have no body, we have no remains. You have to believe basically every word that comes out of Crystal Lee Kenny's mouth to, in fact, convict in this particular case. Now, one of the instructions that the jury will receive is credibility of witness instructions, and it will say you can believe some, part, all, or none of a witness's testimony. So we'll see what the jury will do. If I was representing Patrick Frazee, what I know at this particular point, I would not put him on the stand. I would rest, and I would get up and argue that the prosecution has failed prove their case beyond a reasonable doubt. Why? Because I have won more trials when the defendant does not testify than when they do. Because the jury takes their jobs very seriously, and they have to look at all the evidence or the lack thereof. And when it goes to the defendant testifying, then all of a sudden it kind of shifts from, did they prove it? Did they have enough evidence to, do we believe what he is saying? Okay. So one more trial when the defendant doesn't testify. Hold the government to their burden of proof. We'll see how it goes. We should have closing arguments possibly by tomorrow. So we'll see, and we'll talk about it. Next on the docket is a case that we brought you the video a couple of months ago, and it is regarding the death of a gentleman in Colorado Springs called Devon Bailey. And Devon Bailey was with a friend of his, and the police made contact with Mr. Bailey and his friend because there was a report that there was an aggravated robbery that had taken place. Well, when the police officer made contact with Mr. Bailey and this other gentleman, Mr. Bailey takes off running. Mr. Bailey is shot in the back 3 times. It's captured on video. A grand jury yesterday decided that these officers who did the shooting, who shot Mr. Bailey 3 times in the back while he was running, will not be charged. The district attorney, Dan May, who's the same district attorney prosecuting the Patrick Frazee case, said that this is the clearest evidence he's ever had in a police shooting, and it's obvious that the officers were aware that Mr. Bailey had a gun. Now, the fact is, Mr. Bailey did have a gun, but it's not clear that he was going for a gun. It looked like he was perhaps reaching to pull up his pants, but either way, he did not pull a gun. He did not turn around, face a gun at anybody. Let's compare that to the case of Walter Scott. For those who do not recall, Walter Scott was a South Carolinian in Charleston about 5 years ago, pulled over for a traffic stop. Things aren't going well. Mr. Scott runs. The officer at the time, Michael Slager, shoots him in the back while he is running away. Officer Slager is indicted and charged with first-degree murder in South Carolina, and at his trial, it hangs, which means they have to redo it. Shortly after that trial, the United States Attorney then files a case alleging violation of Mr. Scott's constitutional rights, and Mr. Slager takes a 20-year plea bargain in exchange for the state murder charges to be dismissed. Now, to be completely honest, Mr. Scott's case, Mr. Scott did not have a firearm, but it was on body cam and he was running away. Ladies and gentlemen, we bring this to you today because if that were you or me who shot somebody in the back while they were running away, you, my friend, would be charged. No doubt about it. Even if the other individual had a firearm, you would be charged. I understand police have a tough job. They get a lot of discretion in their job, but it should not necessarily give them a free pass. I have no stake in this particular case. I just find that it's rather interesting, very similar cases, and obviously different results based upon a grand jury. Let's quickly touch on a grand jury. Grand jury, you have grand juries, and then you have a petite jury. A petite jury is the jury that hears a case. A grand jury is made up of at least usually 13 to 15 people, could be as high as 25 depending on the jurisdiction. They hear evidence to establish probable cause. They don't hear all the facts, and you've heard of the quote, you could indict a ham sandwich. It is true. A grand jury will hear some evidence. They are instructed by the prosecutor. You've heard evidence. You shouldn't consider this. You shouldn't consider that. But we believe there's evidence. Sign here. And they sign. Very rarely do you hear of a runaway grand jury where they say, we want to indict somebody when the DA is saying not to. I've had cases where they say, yeah, don't worry, bring your client in. It's all good. No charge. Hint, hint, wink, wink, nudge, nudge. It depends on the prosecutor, okay? If they want to charge somebody, they'll charge it. If they don't think charges will be filed, they don't present enough evidence or they present the evidence they need. Remember, the defense is never in there. There's no cross-examination. The grand jurors can ask some questions, but they can't delve into it and be complete investigators. They simply hear and say, yeah, I think there's probable cause. What is probable cause? Would a reasonable person believe that a crime was committed and the person that we're accusing of that crime may have had something to do with it? Huge, huge standard. Probable cause to get it charged down here, okay? Proof beyond a reasonable doubt. You need that much. It's huge, huge. Highest form of proof known in the law. Proof beyond a reasonable doubt. Not even close to probable cause. Next on the docket is our daily contestant for the Dumb Criminal of the Week. He, along with other contestants, will have an opportunity to win, yes, a Crime Talk mug. And if they are, in fact, selected as the Dumb Criminal of the Week, they simply just have to contact me at scott@scottreisch.com, and we will send to them a Crime Talk mug. So our contestant today, and thanks for playing along, John Picard, 52, from Florida. who was pulled over for erratic driving. And when he was pulled over, he basically asked the cop for a pass because he said, I'm running a little late because, well, I was having an extramarital tryst and I need to get home so I don't get in trouble. The police officers did not give Mr. Picard a pass, and in fact, he was busted and arrested. And of course, what do they find in his shirt pocket when they're booking him in? Yes, that's right, drugs, okay? And what does Mr. Picard do? Does he deny it? Does he remain silent? Does he say, hey, bro, that's not my shirt? Because they have to prove knowledge, right? But if he's borrowed somebody's shirt, how does he know it's there, right? Joke. Every defense attorney has heard the that ain't my pants defense, okay? Some of us have even run that defense, okay? Doesn't work very well. And so Mr. Picard, not only does he have to deal with his traffic issue now he has to deal with possession of a controlled substance, which is a felony, all because he was having his extramarital tryst. So I'm sure Mr. Picard's wife came and bonded him out, unaware of all of the circumstances surrounding it, but I'm sure it was an unpleasant ride home with Mr. Picard and his wife. I once had a situation where a client retained me. His wife picked me, hired me. I go down, meet him at the jail. This is on a weekend, and we're heading out, and the wife didn't seem too particularly concerned about her husband, thinking he could probably find his own transportation home. I believe she waited for him. It was going to be an uncomfortable ride. No. What was she more concerned with? Yes, she was more concerned with whether it would be possible if we could have access to the car so that she could retrieve the baby seat so that the baby could be properly secured in the car. Yeah, I wouldn't want to be that man on that drive home. That was going to be awkward. That's all we have for you today on Crime Talk. Thanks for watching. If you like the channel, please subscribe. If you like the video, hit the thumbs up. Leave me a comment. Do you think this Patrick Frazee guy is going to walk, or do you think the prosecution has presented enough? Leave a comment. Let me know. Have a great day, and thanks for watching Crime Talk.